Hello students, today we will be discussing the topic of a critical analysis of the changing dynamics of gender bias and loss in India. Introducing the topic, the women have been discriminated in the country from time unknown. They have been treated in a very unfair manner. It is sad since there are numerous goddesses worshipped in this country. The country has been striving ever since the independence to protect the women from discrimination. The Merriam-Webster dictionary defined discrimination as the practice of unfairly treating a person or a group of persons differently from other people or group of people. Discrimination strikes at the very heart of being human. It is treating someone differently simply because of who they are or what they believe. We all have the right to be treated equally regardless of our race, nationality, class, caste, religion, belief, sex, language, sexual orientation, gender identity, age, health or other status. Yet, all too often, we hear heartbreaking stories of people who suffer equality simply for belonging to a different group from those in power. Constitutional provisions. The Constitution of India plays a pioneer role in protecting the women from discrimination and ensuring gender justice in the present times. It can be said that Constitution, being the supreme law of land, significantly addresses the questions related to women and also respond to the challenges. The whole legal system is to be framed according to the provisions of the Constitution of India. But law alone cannot change the society in a night, but it will certainly bring positive changes and also ensure that the discriminated cannot be dealt in any manner whatsoever. Article 14 not only provides the British concept of equality before law, but also give equal protection of law, which is an American concept. The provisions have wide connotation and protect the women from discrimination from their counterparts. Article 15 Clause 1 specifically prohibits any kind of discrimination against women on the basis of sex, caste, etc. And Article 15 Clause 3 of the Constitution makes special provision for women favoring laws in order to protect the women and uplift them from such discrimination. Article 16 of the Constitution provides for equality of opportunity to all in matters relating to public employment or appointment to any office and specifically forbids discrimination inter alia on the ground of sex. These articles are all justiciable and form the basis of our legal constitutional edifice. Not only the state is required to protect the women from discrimination, but it is the fundamental duty of every individual to ensure that dignity of women is protected. Article 51A read as follows: It shall be duty of every citizen of India to promote harmony and spirit of common brotherhood among all the people of India, transcending religious, linguistic and regional or sectional diversities, to renounce practices derogatory to the dignity of women. Thus, it forms part of our personal obligation to protect the dignity of women and not to resort to any activities which are derogatory to the women. Statutory provisions. The Equal Remuneration Act 1976, the Maternity Benefit Act 1961, the NREGA 2005, the Prenatal Diagnostic Technique Regulation and Prevention of Misuse Act 1994, the Dowry Prohibition Act 1961 and the Immoral Traffic Prevention Act 1956 are some of the laws related to women empowerment in India. Although these principles are strictly not justiciable, the Supreme Court of India, through its judicial activism, has infused dynamism into these non-justiciable provisions and issued direction to the state to implement them. The 73rd and 74th Amendment of year 1993 to the Indian Constitution have served as a major breakthrough towards enhancing the women's participation in democratic process. The Supreme Court in Muthamma versus Union of India and Air India versus Nargesh Mirza struck down discriminatory service conditions requiring female employees to obtain government permission before marriage and denying married and pregnant women the right to be employed. In Vishakha versus State of Rajasthan, the Supreme Court observed that equality in employment can be seriously impaired when women are subject to gender-specific violence such as sexual harassment in the workplace, and therefore issued the guidelines to ensure that women have equal working conditions and are protected from sexual harassment. In McKinnon versus Company Limited case, the court observed that there was discrimination in payment of wages to lady stenographer, and such discrimination was being perpetuated under the garb of a settlement between the employees and the employer. The court finally not only made it mandatory to pay equal remuneration to lady stenographer as their male counterparts, but also observed that the ground of financial incapability of the management cannot be a ground to seek exemption from Equal Remuneration Act 1976. Hindu Succession Amendment Act 2005 is a piece of central legislation that was brought into force in all our states. The act confers equal right of inheritance to Hindu women along with men, thus achieving the constitutional mandate of equality. Interpretation of the guardianship law in the light of Article 15 by Supreme Court in Geethal versus Reserve Bank of India could equate the position of a mother to that of father in the matter of guardianship. Ban on prenatal diagnostic testing. Preconception and Prenatal Diagnostic Technique Act 1994 is an act of the Parliament of India enacted to stop female feticide and arrest the declining sex ratio in India. The act banned prenatal sex determination. This process began in early 1990s when ultrasound technique gained widespread use in India. There was a tendency for families to continuously produce children until a male child was born. Fetal sex determination and sex-selective abortion by medical professionals has grown today into a ₹1,000 crore industry. Social discrimination against women and a preference for son has been promoted. Objectives of the Act. The main purpose of enacting the Act is to ban the use of sex selection techniques before or after conception and prevent misuse of prenatal diagnostic technique for sex-selective abortions. Salient features of the Act. Offences under this Act include conducting or helping in conduct of prenatal diagnostic technique in the unregistered unit, sex selection on a man or women, conducting P&D test for any purpose other than the one mentioned in the Act, sale, distribution, supply, renting, etc. of any ultrasound machine or any other equipment capable of detecting sex of the fetus. Main provisions in the Act are as follow. The Act provides for the prohibition of sex selection before or after conception. It regulates the use of prenatal diagnostic techniques like ultrasound and amniocentesis by allowing them their use only to detect genetic abnormalities, metabolic disorder, chromosomal abnormalities, certain congenital malformations, hemoglobinopathies, sex-linked disorders. No laboratory or center or clinic will conduct any test including ultrasonography for the purpose of determining the sex of the fetus. No person, including the one who is conducting the procedure as per the law, will communicate the sex of the fetus to the pregnant women or her relatives by words, sign or any method. Any person who puts an advertisement for prenatal and preconception sex determination facilities in the form of a notice, circular, label, wrapper or any document or advertises through interior or other media in electronic or print form or engages in any visible representation made by means of hoarding, wall painting, signal, light, sound, smoke or gas can be imprisoned for up to 3 years and fined ₹10,000. Compulsory registration. The Act mandates compulsory registration of all diagnostic laboratories or genetic counseling centers, genetic laboratories, genetic clinic and ultrasound clinic. Preconception sex selection. Recently developed techniques of sex at the time of conception like Erickson method, X and Y chromosome separation and pre-implementational genetic diagnosis are also brought under the ambit of the law. Maintenance of records. All genetic counseling centers, genetic laboratories, genetic clinics and ultrasound clinics, irrespective of whatever they are involved as regards diagnosis for gynecological or other purposes, would now have to maintain records of all the tests conducted by them. Implications of the amendment of 2003 in the Act are as follows. Number 1, bringing ultrasounds within the ambit, empowering the Central Supervisory Board, constitution of state level supervisory board. Number 3, provision for more stringent punishments. Number 4, empowering appropriate authorities with the power of civil court for search, seizure and sealing the machines and equipments of the violator. Number 5, regulating the sale of the ultrasound machines only to registered bodies. The Sexual Harassment of Women at Workplace Prevention and Prohibition and Redressal Act 2013. The Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 is a legislative act in India that seeks to protect women from sexual harassment at their place of work. It was passed by the Lok Sabha on 3rd September 2012. It was passed by Rajya Sabha, the upper house of Indian Parliament, on 26 February 2013. The bill got the assent of President on 23 April 2013. The Act came into force from 9 December 2013. This statute superseded their Vishakha guidelines for prevention of sexual harassment introduced by the Supreme Court of India. It was reported by the International Labour Organization that very few Indian employers were complainant to this statute. Most Indian employers have not implemented the law despite the legal requirement that any workplace with more than 10 employees need to implement it. The government has threatened to take some stern action against employers who fail to comply with this law. Objectives of the Act: to provide protection against sexual harassment of women at workplace and for prevention and redressal of complaints of sexual harassment and for matters connected therewith or incidental thereto. It addresses sexual harassment results in violation of fundamental rights of the women to equality under Article 14 and 15 of the Constitution of India, and her right to life and to live with dignity under Article 21 of the Constitution, and right to practice any profession or to carry on any occupation, trade or business, which includes a right to a safe environment free from sexual harassment. The protection against sexual harassment and right to work with dignity are universally recognized human rights by international conventions and instruments such as Convention on Elimination of All Forms of Discrimination Against Women, which has been ratified on 25th June 1993 by the Government of India. To make provisions for giving effect to the said Convention for Protection of Women against Sexual Harassment at Workplace. Background and provisions of the Act. According to Press Information Bureau of the Government of India, the Act will ensure that women are protected against sexual harassment at all workplace, be it in public or private. This will contribute to realization of their rights to gender equality, life and liberty and equality in working conditions everywhere. This sense of security at the workplace will improve women's participation in work, resulting in their economic empowerment and inclusive growth. The Act uses a definition of sexual harassment which was laid down by Supreme Court of India in Vishakha versus State of Rajasthan. Article 19(1)(g) of the Indian Constitution affirms the right of all citizens to be employed in any profession at their choosing or practice their own trade or business. Vishakha versus State of Rajasthan establishes that actions resulting in a violation of one's right to gender equality and life and liberty are in fact a violative of women's right in the workplace and is thus not just a matter of personal injury. Under the Act, which also covers students in school and colleges as well as patients in hospital, employers and local authorities will have to set up grievances committee to investigate all complaints. Employer who fail to comply will be punished with a fine up to Rs 50,000. The legislative progress of Act has been a lengthy one. The bill was first introduced by Women and Child Development Minister Krishna Tirath in 2007 and approved by the Union Cabinet in January 2010. It was tabled in Lok Sabha in December 2010 and referred to Parliamentary Standing Committee on Human Resource Development. The committee's report was published on 30th November 2011. In May 2012, Union Cabinet approved an amendment to include domestic workers. The amended bill was finally passed by Lok Sabha on 3rd September 2012. The bill was passed by Rajya Sabha, the upper house of Indian Parliament, on 26th February 2013. It received the assent of the President of India and was published in the Gazette of India dated 23rd April 2013 as Act number 14 of 2013. Major features of the Act. The Act defines sexual harassment at workplace and create a mechanism for redressal of complaints. It also provides safeguards against false or malicious charges. The definition of aggrieved women who will be protected under the Act is extremely wide to cover all women irrespective of her age or employment status, whether in the organized or unorganized sectors, public or private, and covers clients, customers and domestic workers as well. While the workplace in the Vishakha guideline is confined to traditional office setup where there is a clear employer-employee relationship, the Act goes much further to include organizations, department office, branch unit, etc. In the public and private sector, organized and unorganized hospital, nursing homes, educational institution, sport institute, stadiums, sport complex and any place visited by the employee during the course of employment, including the transportation. Even non-traditional workplaces which involve telecommuting will get covered under this law. The committee is required to complete the inquiry within a time period of 90 days. On completion of the inquiry, the report will be sent to the employer or the district officer as the case may be. They are mandated to take action on the report within 60 days. Every employer is required to constitute an internal complaint committee at each office or branch with 10 or more employees. The district officer is required to constitute a local complaints committee at each district and if required at the block level. The complaints committee have the power of civil court for gathering evidence. The complaint committees are required to provide for conciliation before initiating an inquiry if requested by the complainant. Penalties have been prescribed for employers. Non-compliance with the provision of the Act shall be punishable with a fine of up to ₹50,000. Repeated violation may lead to higher penalties and cancellation of license or registration to conduct business. Hindu Succession Act 1956. The Hindu Succession Act 1956 is an act of the Parliament of India enacted to amend and codify the law relating to intestate or unwilled succession among Hindus, Buddhists, Jains and Sikhs. The significant amendment related to removal of discrimination was made in year 2005 by Hindu Succession Amendment Act 2005. Under Hindu Succession Act 1956, females are granted ownership of all property acquired either before or after the violation of the victim's fundamental right under Article 19(1)(g). The case ruling establishes that sexual signing of the Act abolishing their limited owner status. However, it was not until 2005 amendment that daughters were allowed equal receipt of property as with son. The invariable grants female property rights. The property of a Hindu female dying intestate or without a will shall devolve in the following order: upon sons and daughter, including the child of any predeceased son or daughter and the husband, upon the heirs of the husband, upon the father and mother, upon the heirs of father and upon the heirs of mother. Muslim Personal Law. Application Act of 1937. The inheritance rights are governed by Sharias and the share of the female are less than males as mandated by Quran. Equal Remuneration Act 1976. It is the duty of employer under the Act to pay equal remuneration to men and women workers for same work or work of a similar nature. No employer can, while making recruitment for same work or work of a similar nature or in any condition of service subsequent to recruitment such as promotions, training or transfer, make any discrimination against women except where the employment of women in such work is prohibited or restricted by or under any law for time being in force. Criminal Law Amendment Act 2013. The Cabinet Ministers on 1st Feb 2013 approved for bringing an ordinance for giving effect to the changes in law as suggested by Verma Committee report. According to former Minister of Law and Justice Ashwani Kumar, 90% of the suggestions given by the Verma Committee report have been incorporated into the ordinance. The ordinance was subsequently replaced by a bill with numerous changes which was passed by Lok Sabha on 19th March 2013. New offences. The new act has expressly recognized certain acts as offences which were dealt under related laws. These new offences like acid attack, sexual harassment, voyeurism, stalking have been incorporated into the Indian Penal Code. Section 326A, acid attacks, imprisonment not less than 10 years but which may extend to imprisonment for a life and with fine which shall be just and reasonable to meet the medical expenses and it shall be paid to the victim. Section 326B, attempt to acid attack, imprisonment not less than 5 years but which may extend to 7 years and shall also be liable to fine. Section 354A, sexual harassment, rigorous imprisonment up to 5 years or with fine or with both in case of offence described in clause 1 and clause 2, imprisonment up to 1 year or with fine or with both in other cases. It only protects the women. Provisions are physical contact and advances involving unwelcomed and explicit sexual over torture or a demand or request for sexual favor or making sexually colored remark or forcibly showing pornography or any other unwelcome physical, verbal or non-verbal conduct of sexual nature. Section 354B, act with intent to disrobe a woman, imprisonment not less than 3 years but which may extend to 7 years and with fine. Only protects the women against anyone who assaults or uses criminal force to any women or abets such act with the intention of disrobing or compelling her to be naked. Section 354C, voyeurism. In case of first conviction, imprisonment not less than 1 year but which may extend to 3 years and shall also be liable to fine and be punished on a second or subsequent conviction with imprisonment of either description for a term which shall not be less than 3 years but which may extend to 7 years and shall also be liable to fine. By implication, women may prey voyeuristically upon men with immunity. The prohibited action defined thus watching or capturing a woman in private act which include an act of watching carried out in a place which is circumstances would reasonably be expected to provide privacy and where victim's genital, buttock or breast are exposed or covered only in underwear or the victim is using a lavatory or a person is doing sexual act that is not a kind of ordinary done in public. Section 354D, stalking, imprisonment not less than 1 year but which may extend to 3 years and shall also be liable to fine. Only protects women from being stalked by men. By implication, women may stalk men with immunity. The prohibited action is defined thus to follow a woman and contact or attempt to contact such women to foster personal interaction repeatedly despite a clear indication of disinterest by such women or monitor the use by a woman of the internet, email or any other form of electronic communication. There are exceptions to this section which include such act being in course of preventing or detecting a crime authorized by state or in compliance of certain law or was reasonable and justified. Concluding the topic, it can be concluded that there are adequate legislation in India which not only removes the discrimination against women but also empowers the women. The Constitution itself makes room for the discriminatory laws in favor of women who are considered the weaker sex, disadvantaged and discriminated in the male-dominated society. The action-wise plan of government in preventing the discrimination has proved the legislation as a failure. The existence of these laws only in the books is the major problem in India. The Supreme Court, however, has taken initiative to and in some cases issued directions to the government as well. But the implementation of these legislation in actual sense is very much necessary to remove the discrimination in the society. I hope the lecture is useful for you. Thank you and have a nice day.